Good day, everyone. Welcome back to our commercial law. Today, we are going to cover on the second topic under the Contract Act, which is the acceptance. So, what Section 2B says about acceptance? When a person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal is accepted becomes a promise. So let's break this into simple words. A proposal means an offer. When the offer is given to someone, that person must show agreement. If the person agrees, it becomes an acceptance. Once the offer is accepted, the offer turns into a promise. This is the basic building block of a contract. The offeree is the person who receives the offer and has the choice to accept or to reject it. For example, A offers to sell his motorcycle to B. B is the offeree because B received the offer. So some easy examples for you to understand. Let's say buying food. Ali says to Bala, "Do you want to buy this chicken rice for 5 ringgit?" If Bala says yes, means Bala accepts the proposal, the offer becomes a promise, meaning Ali promises to sell and Bala promises to pay 5 ringgit. So for summary for this particular slide, offer plus acceptance will become promise. Acceptance happened when the offeree agrees to the offer. Without acceptance means there is no promise, there is no contract. Moving on to the next slide, the condition of a valid acceptance. So what makes an acceptance valid? Acceptance must be absolute and unqualified. These requirements come from Section 7A of the Contract Act 1950. So what does Section 7A says? It says that acceptance must be absolute and unqualified. So let's simplify this. Acceptance must be clear, complete, and 100% agree with the original offer. You cannot change the offer. You cannot add any new conditions. If you change even a small part of the offer, it is not acceptance. It becomes a counter offer. So, to form a contract, acceptance must follow exactly what the offerer proposed. So if you modify the offer, it is not acceptance. Let's take, for example, I sell this phone to you for 500 ringgit. If you answer, okay, but can you include a phone case? This is not an acceptance. Or if you say, okay, but 450 can, it's not an acceptance. These answers changed the offer. Therefore, the acceptance is not valid. Let's take, for example, another example. In the tuition center, the offerer says, I can teach you maths for 30 ringgit per hour. The contract is accepted or valid when the reply is, okay, I agree with 30 ringgit per hour. This is an absolute acceptance. But if the reply is, can make it to 25 ringgit per hour, this is a counter offer. Okay, but only on weekend. This is a conditional acceptance. So for quick summary for this particular slide, a valid acceptance must follow the offer exactly. There is no changes. There is no new condition. It must be clear and final. If you change the offer, then it becomes a new offer, or what we call as counter offer. Now let's look at counter offer. What happens when someone changes the offer instead of accepting it? A counter offer happens when the offeree, the person receiving the offer, changes, modify, or adds new conditions to the original offer. When this happens, the law treats it as a new offer. So a counter offer means the rejection of the original offer. Once the counter offer is made, the original offer is considered cancelled or rejected. The offeree cannot later turn back and accept the first offer unless the offerer offers it again. This is why acceptance must be absolute and unqualified. If there's any changes, means not acceptance, and it is a counter offer. Let's say an example, an examples of a house rental. The offer is rent 1,000 per month. Let's say there's a response, I accept, but can you include free Wi-Fi? So this is a counter offer, not acceptance. And another response, you cover electricity, then I agree. Again, this is not acceptance because he is adding a condition. So for this particular slide, changing the offer means it's a counter offer. A counter offer means rejection of the original offer. Acceptance must follow the original offer exactly. If you add conditions or change anything, it is not acceptance. So let's look at this slide. These slides explain what happened after a counter offer is made, especially when the offeree tries to get back and accept the original offer. When B changes the offer, example, changes the price, B is making a counter offer. A counter offer automatically means the original offer is rejected. The original offer cannot be accepted anymore. The counter offer becomes a new proposal. So by looking at the situation given in this particular slide, A offers to sell his car to B for 50,000. B says he wants to buy it for 40,000. So this is a counter offer, not acceptance. So because of this, the original 50,000 offer is cancelled. B has rejected A's original offer. B has created a new offer, which is 40,000. But what if B later changes his mind? If later A refuses to sell the car and B suddenly says, okay, I accept your 50,000 offer, then there is no valid contract. Why? Because when B made the counter offer 40,000 earlier, B already rejected A's original offer. Therefore, B cannot revive the 550K offer unless A agrees to offer it again. So, a counter offer cancels the original offer. After rejecting the offer once, you cannot accept it anymore unless the offerer offers again. Making a counter offer means making a new proposal. So no contract exists if the original offer is already rejected. So let's look at height versus range, a case in 1840. Okay, so it is a very important case in contract law about offer, counter offer, and acceptance. This case teaches us one simple rule. If you make a counter offer, the original offer is automatically cancelled. So let's look at facts of the case. On 6th June, Ranch, the defendant, offered to sell his estate or his land to Hyde, the plaintiff, for £1,000. On 8th of June, Hyde replied and said, I agree to buy it for £950. So this is not acceptance, this is a counter offer. However, Ranch did not reply immediately. On 27th of June, Hyde tried again and said, okay, I accept your original offer of £1,000. But Ranch refused to sell. The question before the court was, can Hyde still accept the original offer after giving a counter offer earlier? The court held says no acceptance took place. Hyde's counter offer of £950 had already rejected the original offer of £1,000. Once rejected, the original offer cannot be revived. So, no contract existed. You might question why. Well, a counter offer. I don't want your offer. Here is my new offer. That is what counter offer sounds like. So this automatically kills the original offer. It is different from asking question, requesting information, clarifying details. Those do not cancel an offer. So, the key principle from Hyde versus Ranch case are a counter offer means rejection of the original offer. Once rejected, the original offer cannot be accepted later. If a counter offer is accepted, means a new contract begins. You must differentiate between a counter offer and a request for information, such as just asking. It will not lead to rejecting. So simple summary for this case, Hyde versus Ranch reminds us that when negotiating a contract, be careful. If you reject an offer with a counter offer, you cannot go back to the original one. Next, let's move on to Stephen Jack and Company McLean. Stephen Jack and Company versus McLean, year 1880. In this case, it teaches the difference between counteroffer and request for information. Now, the fact of this case, McLean, the defendant, offered to sell iron to Stephen Jack, the plaintiff. The plaintiff sent a telegram asking, "Please tell me whether you can accept payment over 2 months, or if not, what is the longest time you can allow?" However, McLean did not reply. McLean assumed, since they asked question, maybe they are not interested. So McLean sold the iron to someone else. The court needed to decide whether plaintiff's telegram was a counteroffer that rejected the original offer, or was it only a request for information? The court said the telegram was not a counteroffer, it was only a request for further information. Therefore, McLean's original offer was still valid at the time. McLean was wrong to assume that the offer had been rejected. A counteroffer means, "I reject your offer. Here is my new proposal." A request for information means, "I am still interested. I just need more details first." In this case, plaintiff did not change the terms. They simply asked for clarifications about payment timing. So the original offer remained open. So the key principle from Stevens Jack versus McLean case is asking for information does not reject an offer. A counteroffer will cancel the original offer. Negotiations must clearly show intention to accept or reject. Silence or delay in replying does not automatically mean rejection. So simple summary for you in this case, that not every reply to an offer is a counter offer. Sometimes it is only a request for clarification. As long as you do not change the terms, the original offer is still alive. Next, acceptance must be communicated in a usual and reasonable manner. So when someone accepts an offer in a contract, the acceptance must be done in a usual and reasonable manner. This requirement comes from Section 7B of Contract Act 1950. So in Section 7B states, acceptance must be expressed in some usual and reasonable manner. This means the way you accept must be normal. It must be logical, practical, and commonly understood. It must be communicated clearly to the person who made the offer. In short, acceptance must follow a method that makes sense in that situation. When the offerer specifies the method of acceptance, the section also says, if the offerer tells you exactly how to accept, then you must accept using that method. If you accept in a different way, the offerer does not have to accept your acceptance. So, the key principle to remember here, Acceptance must be communicated clearly. The method must be usual and reasonable. If the offerer provides a specific method, you must follow it. If you are using a wrong method, then there is no valid acceptance. Silence cannot be accepted unless the offerer allows it. Let me give you an example. The offerer says, please let me know by WhatsApp if you agree. Offeree replies by WhatsApp. So it is a valid acceptance because he is replying using usual and reasonable ways. If the offeree replies by email instead, it is still generally accepted because email is also a normal communication method. So, simple summary for you. Section 7b ensures that acceptance is done in a clear, proper, and practical way. If the offerer tells you how to accept, you must follow the method exactly. If not, the agreement may not be valid. Let's look at Eliasson versus Henshaw, a case 1819. So this case shows the importance of following the exact method of acceptance when the offerer specifies a particular manner. If the offerer says, accept my offer in this way, then the offeree must follow it. Otherwise, the acceptance is invalid. So let's break down what happened in this case. Eliasson offered to buy flour from Henshaw. Eliasson clearly instructed, send your acceptance by wagon to a specific place together with the acceptance letter. This means Eliasson wanted the response sent through a particular method, which is the wagon. But Henshaw did not follow the instruction. Henshaw sent a letter by mail instead. Henshaw thought that the letter would reach Eliasson faster. But Eliasson rejected the acceptance because it was not the form he required. So the issue here is the acceptance valid if the offeree does not follow the required method of acceptance? The court held says that Eliasson was entitled to reject the acceptance because Henshaw did not follow the method of acceptance required. Therefore, no valid contract was formed. Even though the mail was faster, it doesn't matter. What matters is, did the offeree follow the exact instruction? In this case, no. When an offerer tells you how to accept the offer, you must follow that method. Why? Because acceptance must be clear, certain, communicated in the prescribed manner. If not, the offerer can reject it. This comes from the rule in Section 7b, Contract Act 1950, which says acceptance must be expressed in the manner prescribed by the offer. So, a simple summary based on this case, Eliasson versus Henshaw, teaches us that if the offerer gives a specific method of acceptance, you must follow. If you are using a wrong method, the offerer can reject. But if the offerer does not reject in a reasonable time, acceptance becomes valid. Section 7B supports this rule in Malaysian law. Now let's move on to the next case, Western Electric versus Wells Development Agency. Now, in this case, it explained an important rule about acceptance by a prescribed method. If the offerer requires acceptance in a specific way, but the offeree uses a different method, the acceptance is not automatically invalid. The key question is, did the offerer reject the method in a reasonable time? If not, the offerer is considered to have accepted that method. This principle is supported by Section 7B, Contract Act 1950. Let's break down this case step by step. Wells Development Agency, the defendant, offered to let their factory to Western Electric, the plaintiff. The defendant said acceptance must be made by filling a specific form. Plaintiff did not use the form. However, plaintiff still occupied the factory and paid monthly rental to defendant. Later, a dispute arose between plaintiff and defendant. Plaintiff claimed damages. Defendant refused, saying, "There is no contract. You did not accept using the prescribed method, which is filling the form." So the issue here is, was there a contract between plaintiff? Is there a contract even though plaintiff did not use the required form of acceptance? Well, the court held says there was a binding contract. Defendant did not object to plaintiff acceptance method. Defendant accepted the monthly rental showing acceptance. Therefore, defendant is legally bound by the contract. This means even though plaintiff did not use the required form, defendant's behavior shows that defendant accepted the acceptance by conduct. Why? Under contract law, if the offerer says acceptance must be done in a specific way, but the offeree accepts in a different way, then the offerer must reject that method within reasonable time. If the offerer does not reject it, the offerer is considered to have accepted the new method. This is supported by Section 7B of the Contracts Act 1950. So the key principle from Section 7B is that if the offerer prescribes a method, the offeree should follow. But if the offeree uses a different method, offerer must object it quickly. If the offerer stays silent and continue with the contract, examples like receiving money, it means the offerer accepts that method and there is a binding contract which is formed. So simple summary for you based on this case, Western Electric versus Welsh Development Agency. It teaches us that a specific method of acceptance should be followed. But if the offeree uses another method and the offerer does not object, and the offerer continues acting like the contract exists, then the offerer has accepted that method by conduct a binding contract exists. This aligns with Section 7B of the Contract Act 1950. Next is on the communications of acceptance. In contract law, acceptance is only valid when it is communicated to the offerer. This rule ensures that both parties clearly understand when a contract has been formed. So acceptance must be communicated. Acceptance cannot stay silent or hidden. The offeree must actively communicate it to the offerer in a clear manner. If the offerer does not know that the offeree has accepted, no contract exists. So in section 2B, signifies his assent. Under section 2B of the Contract Act 1950, the law says a proposal is accepted when the person to whom the proposal is made signifies his assent. The phrase signifies his assent means the offeree must show, express, or communicate their acceptance. The offerer must receive or be aware of the acceptance. So acceptance must reach the knowledge of the offerer. So when is communication complete? Communications of acceptance is complete only when the offerer becomes aware of it. Even if the offeree already sent the acceptance, it does not count until the offerer actually knows about it. So simple summary in this slide, acceptance must be communicated to the offerer. Section 2B requires acceptance to be expressed. Acceptance is only effective when the offerer knows about it. Silent acceptance is not valid. And wrong communication means there is no contract exists. So let's continue into section 3. In contract law, it is not enough for a person to intend to accept an offer. The law requires acceptance to be communicated through some action that clearly shows agreement. This is supported by Section 3 of the Contract Act 1950, which is the communications of acceptance. Now, what Section 3 says? Section 3 states that communications of acceptance may be made by any act or by any conduct that shows the offeree intends to communicate the acceptance. This means acceptance can be shown through words, spoken or written, action, or conduct that clearly indicates agreement, as long as the action is meant to communicate acceptance. Mere intention is not enough. Section 3 also implies just thinking I accept is not acceptance. Keeping quiet is not acceptance. Accepting in your mind is not acceptance. Acceptance must be shown in some way to the offerer. If there is no communication, then there is no acceptance, no agreement, no contract. So Section 3 teaches us acceptance can be communicated through words or actions. Acceptance must be intended to communicate agreement. Mere intention without communication means no contract. Conduct that shows agreement is valid communication. Silence is not acceptance. Only when acceptance is expressed or indicated through conduct, a valid contract can be formed. Now let's look at Powell versus Lee. Now, this case explains an important rule about communication of acceptance. Acceptance must be communicated by an authorized person. If it is not officially communicated, there is no contract. So let's break this case step by step. Powell, a plaintiff, applied for a position of headmaster in a school. The Board of Managers discussed and passed a resolution selecting Powell for the post. However, the board did not officially inform Powell about the appointment. Instead, one manager, acting on his own personal capacity, told Powell that he was selected. Later, the board changed their mind and canceled the appointment. Powell said, "There is already a binding contract. You selected me." So the issue in this case is that, was there a contract if the acceptance was not officially communicated to Powell? The court held says no contract existed because the acceptance or the appointment was not communicated by an authorized person. The manager who told Powell did not have authority to communicate acceptance on behalf of the board. Therefore, Powell was never officially informed and no contract was formed. So the key legal principle here is that acceptance must be communicated by a person who is authorized to do so. If the communication comes from the wrong person or someone acting personally or someone without authority, then the acceptance is not valid. This is connected to the rule in contract law. Communication must come from the offerer or an authorized representative. So, simple summary based on Powell versus Lee case, acceptance must be communicated. It must come from someone authorized. A personal or unofficial message means it is not valid communication. Without proper communication means there is no contract exists. Even if decision was made internally, it has no effect until officially communicated. Now let's continue with effect of silence in acceptance. Now in contract law, acceptance must be communicated to the offerer. Because of this, silence is generally not accepted. This rule protects both parties and ensures no one forced into a contract without clearly agreeing. General rule: silence is not acceptance. Acceptance must be communicated. Acceptance must be expressed through words, actions, conduct, or behavior that clearly indicates agreement. But silence cannot communicate anything. Therefore, silence of the offeree is not considered valid acceptance. Let's look at Fraser versus Everett case. Now, the court stated that there was no rule of law saying that silence gives consent applicable to mercantile contracts. This means you cannot assume someone accepts just because they did not reply. Silence does not equal agreement. Acceptance must come through actual communication. Next, offerer cannot force acceptance by silence. The offerer cannot create conditions like, if you don't reply, you have accepted. The law does not allow this. Why? Because this would unfairly force people into contract without their consent. Now let's look at the next case, Feldhaus versus Binley. The fact of the case: plaintiff discussed buying a horse from his nephew. Plaintiff told the nephew, if I hear no more about him, I consider the horse mine. The nephew did not reply. 6 weeks later, the nephew asked the auctioneer to keep the horse out of sale. The auctioneer made a mistake and sold the horse. Plaintiff sued the auctioneer. The issue here was the nephew's silent acceptance of plaintiff's offer. The court held says that no, there was no acceptance. Plaintiff had no right to impose acceptance on the nephews through silence. The nephew never communicated acceptance. Therefore, no contract existed. So the key principle to remember here is that silence does not mean it's not acceptance, even if the offerer says so. Offerer cannot create acceptance by saying, if I don't hear from you, you accept. Acceptance must be communicated either through words, writing, or clear action. Silence only becomes acceptance if the offeree intentionally uses silence as communication, and the offeree has a duty to speak. Now, let's continue with unilateral contract. Now, what is a unilateral contract? A unilateral contract is a type of contract where one party makes a promise and the other party accepts by performing an act. So, offerer makes a promise. Offeree accepts by doing something, not by promising. Now, examples of unilateral contracts. A. General offer for a reward. Example, 500 ringgit reward for anyone who finds my lost dog. Only one promise is made. I will pay you 500. Acceptance happens when someone finds and returns the dog. No need to say, I accept. The second example of unilateral contract, offer with a prescribed mode of acceptance. For example, if you return this bracelet to me, I will pay you 200 ringgit. Acceptance happened when the act is done. Unilateral contracts are common in reward cases. So when does a unilateral contract happens? There are two situations. Situation number one, implied stipulation by offerer. This is an implied indication from the offerer that doing this act is enough to show acceptance. For example, there is a poster says, reward 100 ringgit for lost wallet. The offerer implies that returning the wallet is enough to accept the offer. No need to inform the offerer before performing the act. Situation number two is positive conduct by the offeree. There must be clear positive action by the offeree that shows, I am accepting your offer. This is important because unilateral contracts do not require verbal acceptance. Acceptance is the action itself. Example of positive conduct, finding and returned a lost item, or completing a task offered with a reward, or following a specific method to accept the offer. Let's look at a famous example under unilateral contract, Carbolic Smoke, Carlyle versus Carbolic Smoke Ball Company. Now, the offerer advertised, use our smoke ball as instructed, and if you still get sick, we will pay you 1,000 pounds. So a customer buys it, use it, and still gets sick. So the customer action means acceptance. So the company must pay. So this is the most famous unilateral contract case. Carlyle versus Carbolic Smoke Ball Company. So simple summary for you for this particular topic, unilateral contract. It is created when the offerer makes a promise for an act. The offeree accepts by performing an act. It usually happens in implied acceptance situations or positive conduct that clearly shows intentions to accept. In short, action means acceptance. So I will continue discussing a little bit more on Carlyle versus Carbolic Smoke Ball. This case was happened in 1893. So this is the most famous case in contract law involving unilateral contracts. So it explains when performance is enough to form a binding contract without communications of acceptance. So let me give you a short recap about the case. So Carbolic Smoke Ball Company advertised a product called Smoke Ball to prevent influenza. They promise 100 pounds to anyone who uses the smoke ball as instructed and still became sick. So Mrs. Carlyle bought it, used it correctly, and still got sick. So she demanded the 100 pounds. The company refused, saying there was no contract because she never communicated acceptance. So the court held says that performance is equivalent to acceptance, as long as that was the intentions of the offerer. In this case, the company clearly intended that using the smoke ball would be taken as acceptance. Therefore, Mrs. Carlyle accepted by performing the act, no need to send a letter saying, I accept your offer. The company is bound to pay. Why communication was not needed? In a unilateral contract, the offerer promises something in return for an act. The offeree accepts by doing the act, not by communicating. So when Mrs. Carlyle used the smoke ball, she accepted the offer. Acceptance was complete upon performance. The company is bound, even though they did not receive any message from her beforehand. So the key legal principle from the case. Number one, a general advertisement can be an offer. The smoke ball advertisement was not just an invitation to treat. It was a real offer to the world. Number two, acceptance can be by conduct. Mrs. Carlyle accepted by doing exactly what the advertisements required. Number three, no need for prior communication in unilateral contracts, especially when the offerer intends that performance is sufficient. The offer is made to the whole world. The act itself is notice of acceptance. Number four, the company showed intention to be bound because they deposited £100 in a bank to show sincerity. So simple summary under Carlyle versus Kabulik smoke ball, it teaches us that unilateral offers can be accepted by performance. There is no need to communicate acceptance beforehand. The performance is equivalent to acceptance. Offerer is bound once the offeree completes the act required. This case is the foundation for understanding unilateral contracts and acceptance by conduct. Let's continue with Arrington versus Arrington. The case happened in 1952. This case explains how unilateral contracts work, especially when the offeree accepts the offer by performing the required act, even if no communication of acceptance is made. Fact of the case. Let's break down the story. A father promised his son and daughter-in-law, if both of you pay off the mortgage installments in this house, I will transfer the house to you once everything is fully paid. So the son and daughter-in-law accepted the offer by starting to pay the mortgage. They paid the installments regularly, and the father knew they were doing so. Later, the father died, and a dispute arose when the estate, the people managing the father's property. The question here, was the father's promise a binding contract? So the court held says that a unilateral contract was created. The father made a promise, and the son and daughter-in-law accepted by performing the required act, which is paying the installments. Acceptance was valid even when without communication. They did not have to say, we accept your offer. Starting to pay the installment is a clear acceptance by conduct. The father and his estate was bound. As long as they continue paying, the estate could not take the house away. So why is this case a unilateral contract? A unilateral contract is created when the offerer promises something in return for an act. The offeree accepts by doing the act. Here, the father promised, pay the mortgage and the house will be yours. The son and wife's acceptance by paying monthly installments. Thus, acceptance by performance, not by word. So, key principles for you to take from this case, Arrington versus Arrington, is that number one, performance means acceptance. Starting to pay the mortgage installments was enough. Number two, there is no need to communicate acceptance. The act itself communicated acceptance. Number three, promise becomes a binding once performance begins. When the son began paying, the father's promise became enforceable. Number four, offer cannot be revoked mid-performance. The estate could not take back the offer while the couple was still paying. This is a major rule for unilateral contracts. Once the offeree begins the required act, the offerer cannot revoke the offer. So, simple summary for you. Arrington versus Arrington teaches us that when a promise is made in return for an act, it is a unilateral contract. Acceptance can be shown through performance, not communication. The act must be done in reliance on the promise. Once performance begins, the offer cannot be revoked. The estate is bound by original promise. In short, doing the act means accepting the offer. Next is on the postal rule. What is the postal rule? The postal rule applies when both parties understand or expect that acceptance will be communicated by post or mail. The special rule states acceptance is complete the moment the letter is posted. Even if the letter is delayed, lost, or never reaches the offerer. This is an important exception to the general rule that acceptance must be communicated. So when does the postal rule apply? The postal rule applies only when the parties contemplate, expect, or agree that acceptance will be made by post. Posting a letter is a reasonable or normal method. The offerer does not exclude the postal rule. If these conditions are met, acceptance is effective once the letter is dropped into the post box. When does the postal rule not apply? The postal rule does not apply if the offerer states a different rule clearly. The offerer requires actual communication. Acceptance is meant to be through instantaneous method, such as WhatsApp, phone call, email, or fax. This slide states that this rule may be excluded by the express term of the offer. Examples of exclusion: your acceptance must reach me, or acceptance is valid only when I receive your reply. If the offer says this, postal rule does not apply. Then why does the postal rule exist? Simple reason: because once the offeree posts the letter, they lose control over it. They have done everything required to accept. It would be unfair to penalize them for delays or mistakes by postal service. So the law protects the offeree by treating acceptance as complete upon posting, not upon receiving. Let's explain an example using a simple form. Here, A sends B a check for 1,000 ringgit. A states that this 1,000 ringgit is for your agreement to sell me your motorcycle. So the check represents consideration and A's proposal. What happened? B then cashes the check. So under legal, B is deemed to have accepted the proposal. B does not need to communicate acceptance directly to A. Cashing the check is a clear conduct showing acceptance. This is similar to unilateral acceptance by conduct. So a simple summary, postal rule is acceptance, is effective when posted, applies only when posting is expected by both parties, works even if the letter is lost. Offerer can exclude this rule by stating specific requirements. Does not apply to instantaneous communication. Acceptance by conduct, like cashing a check, can also show agreement. Next, we are looking at the acceptance through post. Acceptance through post is a special situation in contract law. It forms part of the postal rule, where acceptance becomes valid as soon as the letter is posted, not when it is received. This is different from the normal rule that acceptance must be communicated and received. When acceptance is complete, according to this slide, acceptance is complete the moment the letter of acceptance is posted. This means once the offeree drops the acceptance letter into the mailbox, the offerer is bound by the contract, even if the letter is delayed, lost, destroyed, or never arrives. In Section 4, subsection 2A of Contract Act 1950, the law clearly states communications of acceptance is complete as against the offerer when it is posted. This protects the offeree because they have done everything required to accept. They no longer control the letter once it enters the postal system. They should not be penalized for postal delays or error. In Section 4, B accepts A proposal by posting a letter. Acceptance is complete against A at the moment the letter is posted. Meaning, even if A never receives the letter, A is still bound by the contract. Why the offerer becomes bound immediately? It is because the offeree completed the required acceptance method. Posting was either agreed or expected by both parties. The offeree cannot control what happens after the letter is mailed. So the law fixed acceptance at the moment of posting to avoid unfairness. So let's look at a case. Enterprise Limited versus Miles Far East Corporation. Here, when a contract is made by post, Acceptance is complete when the letter is put in the post box, and that is the place where the contract is made. So this case confirms the postal rule applies only to postal communication, not to instantaneous method like phone, fax, WhatsApp, or email. So when will the postal rule does not apply? The offerer may exclude the rule by stating, acceptance must reach me. Acceptance is valid only upon receipt. You must notify me directly. Now, if the offerer says this, acceptance is not valid upon posting. So, summary for you, postal rule means acceptance is valid when posted. This is based on section 4, subsection 2a. Offerer is bound once the letter is mailed. Delay or loss of letter does not affect the contract. It can be excluded if the offer says so. It is not applicable to email, WhatsApp, fax, or instant messages. Let's continue with another case, Ignatius versus Bell. This case happened in 1913. Now, this case is an important Malaysian authority on the postal rule, showing how acceptance is valid once posted, even if the offerer receives it late. So the fact of the case, let's break the story into easy steps. The defendant gave the plaintiff an option to buy a piece of land. The condition was the option must be exercised on or before 20th August 1912, and the plaintiff must give notice in writing. Plaintiff accepted the offer by posting a letter on 16th August 1912. However, defendant only received the letter on 25th August 1912, which is after the deadline. Defendant refused to sell the land. Plaintiff then sued defendant. So the issue in this case was acceptance valid even though the letter reached the defendant after the deadline? So the court held says the parties contemplated the use of post. Both plaintiff and defendant expected communication through postal service. Therefore, the postal rule applies. Section 4, subsection 2a, Contract Acts. Acceptance was complete when the letter was posted. The important date is 16th August 1912, not 25th August when the letter was received. A valid contract was formed because acceptance was posted before the 20th of August. So the defendant is bound, even though defendant received the letter late. The acceptance date is legally the date of posting. So the key principle under Section 4.2a, Contract Act 1950, acceptance is complete as against the offerer when the letter is posted. This applies even if the letter is delayed, the letter arrives after the deadline, the letter gets lost, the offerer never receives the letter, as long as it is posted correctly. So why is this case important? This case illustrates that the postal rule protects the offeree. Posting equals acceptance. Actual receipt by the offerer is not required. The court will enforce acceptance based on the date of posting, not the date of delivery. So simple summary for you for this case is Ignatius versus Bell shows that parties intended to use the postal rule automatically applies. Acceptance is complete upon posting. Offerer is bound from the moment the letter is mailed. Late delivery does not invalidate acceptance. In short, date of posting is the date of acceptance. Next, let's look at Household Fire Insurance Company Limited versus Grant. This case happened in 1879. So the fact of this case, the defendant applied to buy shares in plaintiff's company. Plaintiff accepted defendant's offer and plaintiff posted the acceptance letter. However, the letter never arrived to defendant. Plaintiff then asked defendant to pay for the shares. Defendant refused and said, I never received any acceptance, so there is no contract. The court held says that acceptance was valid once plaintiff posted the letter. Here, the postal rule applies. A binding contract was formed even though defendant never received the letter. The court says once a properly addressed acceptance letter is posted, the offerer is bound. This case confirms the classic postal rule. Now, in Section 4, subsection 2b of Contracts Act 1950, acceptance complete against the offeree. So the offeree is bound by contract when the offerer receives the acceptance. This means against the offerer, acceptance when complete when posted. Against the offeree, acceptance complete only when the letter reaches the offerer. Here, B accepts A proposal by post. Communication is complete against B when A receives the letter, meaning B cannot withdraw his acceptance after A receives his letter. Until A receives it, B may still revoke. Let's look at another case, which is Holwell Security Limited versus Hutch. This case explains when the postal rule does not apply. So let me give you the simple fact of this case. Defendant written offer included a special condition. The option shall be exercised by notice in writing to the defendant. Plaintiff posted the acceptance letter, but the letter never arrives. Plaintiff claimed the contract existed because he posted the letter. The court held says that the postal rule does not apply here. Why? Because the offerer, who is the defendant, required actual notice in writing to the defendant. This means acceptance is only valid if defendant receives it. Posting is not enough. There is no contract formed because defendant never receives the letter. So the key principle from Holwell versus Hodge, offerer can exclude the postal rule by using clear words such as must reach me, notice in writing to the offerer, effective upon receipt, must be received by. So if the offerer includes such terms, postal rule does not apply. So in understanding all the three cases, household fire versus grant, posting is a valid acceptance even if letter never arrives. Okay, that is found in section 4 2b. Offeree is bound only when acceptance reaches the offer. And then another case, Holwell Security versus Hodges, offerer can block postal rule by requiring actual notice. So thank you very much for your attention. I will see you guys again on our next topic.